Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about one of the most important requirements for somebody who would like to receive a green card in the United States. It's the requirement that they will be inspected and admitted or paroled into the United States in order to adjust their status to one of a lawful permanent resident. You will find this requirement on every I-45 form. Almost every time when you will be applying for a green card, you will have to show that you had this legal entry. There are, of course, some circumstances and applications when you don't have to show that. For example, if you're a victim of abuse, a battered spouse of a US citizen, you will not have to show that. If you're applying for one of those humanitarian visas like U visa, T visa, you don't have to show that you have a legal entry. But most likely, if you are an immediate relative of the United States citizen, right, a relative of the United States citizen, like a parent or a spouse or a child under 21, you will have to show that you entered the United States legally. Of course, there is one exception to that, 245I. But to qualify for this, you have to be in the United States for a very long time, from 2000. So currently not many people will qualify for that. Plus a petition would have to be filed for you before April 30th, 2001. But let's focus on the requirement of being inspected and admitted. Many overlook that there is a 2010 Board of Immigration Appeal decision that states that you actually are found to comply with the requirement if there was a procedural compliance and not substantive. What does it mean? It means that if an officer at the border through the checkpoint where you went looked at you and allow you to come in, then you have a legal entry. Now, I will tell you that this thing works usually only before the immigration judge, unfortunately, and not before USCIS. Even though, in my belief, USCIS, because it comes from Board of Immigration Appeals, has to already adopt this as a policy and allow people to adjust when they can establish credibly that it happened. But how do you do this? Well, first of all, your testimony matters. You better present a very consistent testimony as to when and how you entered the United States, how you went through the checkpoint, what kind of documents you showed to the officer, or maybe the officer did not ask you to show the documents. And usually you will be required to bring a witness or two to support your testimony. From the cases that are published dealing with this issue, we can state that if you bring a witness, your case is much stronger than when you don't. Okay? Also, of course, the judge has to believe you. You have to be found credible. So if you in one document state that you came in 1987, and in another document you state that you came in 1989 or 2000, and you provide different circumstances, most likely your case will be denied. So make sure that you are consistent and you're telling the truth, okay? And you have to have a witness. Again, it works in court. Unfortunately, as of now, from what I know, and especially in New York, it does not work for whatever reason with USCIS, even though it should, really it should. So this is the law. It's a very important point. Keep it in mind, because if you are in court and you have this issue and you did enter legally this way, you may be able to adjust your status without the need for a waiver. Okay, perhaps now you qualify for adjustment and you don't have to go through cancellation or removal. So it's something that you need to discuss with your attorney. I hope you have one, and keep this in mind. And I hope this video was helpful, and you can read more about various immigration things, situations, and how the courts look at issues, how the USCIS looks at different issues on our website, www.shautsova.com. Thank you.